A law must first name itself before it can bind a people. What the code says, plain meaning. Article 1.01 officially names this body of law, the Texas Code of Criminal Procedure. That is all it does. No powers, no duties, no exceptions. But its purpose is not small. Why it exists. This article establishes authority and identity. Every arrest, every warrant, every courtroom order traces back to this name. If a rule governs how criminal cases are handled in Texas, it speaks through this code. What this means for you. When someone asks, where does the authority for arrests, warrants, bail, and trials come from? The answer begins here. Not policy, not tradition, not preference. The Code of Criminal Procedure. Without a name, power drifts. With a name, it binds. Art 1.03. Objects of this code. The law does not exist to favor the state, nor to excuse the guilty. It exists to hold both in balance.
What the code says, broken down carefully. Article 1.03 explains why the Code of Criminal Procedure exists, its objects or goals.
The Code of Criminal Procedure is designed to prevent crime, ensure punishment is carried out by due course of law, protect the rights of the accused, ensure fairness and uniformity in criminal proceedings, carry out constitutional guarantees. Each object matters. None cancel the others. 1. Prevent crime. The Code of Criminal Procedure gives peace officers legal tools to stop crime before it spreads. Arrest authority, warrants, detentions, protective orders, but prevention must be lawful. The state may act early, but never blindly. 2. Ensure punishment by due course of law. Crime is punished only through lawful arrest, lawful charging, lawful trial, lawful conviction, not shortcuts, not assumptions. Guilt does not grant permission. Procedure does. This is why illegal arrests and bad searches destroy cases. 3. Protect the rights of the accused. The Code of Criminal Procedure exists to restrain the government, not just criminals. It protects the right to remain silent, the right to counsel, the right to bail, the right to be free from unlawful search and seizure, even when the accused is guilty. The law is tested not by how it treats the innocent, but by how it restrains itself against the guilty. 4. Ensure fair and uniform application of the law. The same crime should be handled the same way in Fort Worth, the same way in El Paso, the same way in Amarillo. This prevents arbitrary enforcement, personal bias, unequal treatment. Justice that changes with geography is not justice. 5. Carry out constitutional guarantees. The Code of Criminal Procedure is how Texas puts the Constitution into action. The 4th, 5th, 6th, and 14th Amendments are not theory. The CCP turns them into procedure. Examples: Miranda warnings, magistration, warrants, bail rules. The Constitution promises rights. The Code enforces them. Peace officers generally. The law begins by deciding who may wear the badge. Not everyone who carries a gun carries its burden. 1. Who this article covers. Article 2. A .001 is the master list of who counts as a peace officer in Texas under the Code of Criminal Procedure. It includes, among others, sheriffs and sheriff's deputies, constables and their deputies, municipal police officers, Texas Department of Public Safety officers, including Texas Rangers, investigators for district and county attorneys, school district police, park rangers, hospital district police, transit police, fire marshals, various state agency investigators, and more. If they are not on this list, or added by another statute, they are not a Texas peace officer under the Code of Criminal Procedure. 2. What are their duties? Their general duties are laid out in Article 2, .051, and those duties apply to all peace officers in this list.
Preserve the peace within their jurisdiction by all lawful means. Interfere without warrant when the code authorizes it, to prevent or suppress crime. Execute all lawful process, warrants, writs, summonses, from courts and magistrates. Notify a magistrate of offenses in their jurisdiction when they have good reason to believe a penal law has been violated. Arrest without a warrant when authorized by law and bring the person before a magistrate. Take possession of certain children and execute specific emergency orders as required by other statutes. In plain terms, regular Texas peace officers equals full criminal enforcement authority, subject to jurisdiction and the rules of the Code of Criminal Procedure. Special investigators. Faith does not grant authority. Allegiance does not grant authority. As with judgment, power is given, and only within its bounds. 1. Who they are. Article 2. A .002 lists federal criminal investigators and certain federal security officers who are not Texas peace officers, but who are given limited Texas powers of arrest, search, and seizure. Examples include Special Agents of the Federal Bureau of Investigation, Special Agents of the Secret Service, Special Agents of Immigration and Customs Enforcement, Special Agents of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, Special Agents of the Drug Enforcement Administration, Postal Inspectors, Internal Revenue Service Criminal Investigators, Naval Criminal Investigative Service, United States Marshals Service, and others. Certain Department of Homeland Security officers at ports of entry or Border Patrol checkpoints, National Park Service and United States Forest Service law enforcement. 2. What are their duties and limits? The Code of Criminal Procedure gives them state-level powers only in specific ways. Generally, they may arrest, search, and seize under Texas law for felony offenses only, unless a subsection expands this further. Homeland Security/Border Patrol at designated crossings and checkpoints. They may detain people believed to be committing certain alcohol-related offenses, public intoxication, driving while intoxicated, intoxication assault, intoxication manslaughter, and must turn them over to a Texas peace officer without unnecessary delay. Some, like National Park Service and United States Forest Service officers, have Texas arrest/search powers inside parks, recreation areas, or forest system lands for any Texas offense committed there. Secret Service agents protecting certain federal protectees get Texas powers for misdemeanors and for any federal crime in the course of those duties. They remain federal officers, not Texas peace officers. Their duty under the Code of Criminal Procedure is to use Texas arrest/search authority only within the specific limits given. To summarize, special investigators equals federal agents, not Texas peace officers, but with limited Texas arrest/search power, usually felonies, specific locations, or specific missions. Peace officers commissioned by tribal council. The tribes were broken. Authority was taken. What remains now is not inherited. It is granted. 1. Who they are. This article allows the tribal councils of the Alabama Coushatta Tribe of Texas, the Kickapoo Traditional Tribe of Texas, the Isleta del Sur Pueblo, to employ and commission peace officers to enforce state law within the tribe's reservation. These commissioned officers are Texas peace officers under the Code of Criminal Procedure while acting under this article. 2. What are their powers and duties? A peace officer commissioned by a tribal council. Within the reservation, has all the powers, privileges, and immunities of a Texas peace officer, may arrest without a warrant under Chapter 14 rules, warrantless arrest authority, for violations of state law. May enforce all traffic laws on streets and highways inside the reservation. Outside the reservation, may arrest for violations of Texas law only if the officer is summoned by another law enforcement agency, or the officer is assisting another law enforcement agency. Other requirements. Must meet all Texas Commission on Law Enforcement licensing standards. Must take the peace officer's oath and post a bond guaranteeing fair and faithful performance. Not entitled to normal state benefits given to other peace officers. To summarize, Tribal Council peace officers equals full peace officer powers on the reservation, limited assist-only powers outside the reservation. Peace officers from adjoining states. Borders do not pause danger, so the law allows the chase to cross the line, but only so far. 1. Who they are. This article deals with commissioned peace officers from states that border Texas, Oklahoma, Arkansas, Louisiana, New Mexico, and the Mexican states on the land border, though the article is written in terms of states adjoining this state. When such an officer is in Texas under the conditions of this article, they temporarily have the same powers, duties, and immunities as a Texas peace officer, but only in very limited situations. 2. What are their powers and duties? They have Texas-style peace officer powers only. When physically transporting an inmate or criminal defendant between a border county and the other state and a medical facility in a Texas border county and back, to the extent necessary to maintain custody during transport, regain custody if the person escapes during transport, when assigned to duty in a border area, if they are in a municipality whose city limits extend within 1 mile of the Texas border, and they are regularly assigned to duty in a county/parish/municipality that adjoins Texas. If they fall under 2, and the Texas municipality's governing body votes to authorize it, they may also enforce that municipality's ordinances. To summarize, adjoining state officers equals Texas peace officer powers only while transporting prisoners near the border or working in a border city, and only to maintain or regain custody or where local law allows ordinance enforcement. Railroad peace officers. Steel rails carry more than freight. They carry risk. The law gives them guardians. 1. Who they are. Article 2. A .005 allows the Director of the Department of Public Safety of the state of Texas to appoint up to 250 railroad peace officers who are employed by railroad companies. They are licensed peace officers, but their role is narrow and specialized. 2. What are their powers and duties? A railroad peace officer may use all authority given to peace officers under the Code of Criminal Procedure, but only when necessary to prevent or stop offenses involving injury to railroad passengers or employees, damage to railroad property, protect railroad property, or property that is in the custody or control of the railroad. Limits and conditions may not issue traffic citations for driver's license violations or general rules of the road. Transportation Code, Chapter 521, or Subtitle C, Title 7. Not entitled to state benefits normally provided to peace officers. Must meet Texas Commission on Law Enforcement standards and be licensed as railroad peace officers. Their employer, the railroad company, not the state, is liable for their acts within the scope of employment and must pay all costs related to appointment or revocation. To summarize, railroad peace officers equals full peace officer powers, but only to protect railroad people and property. No traffic tickets, no state benefits. Railroad pays and takes the liability. Special Rangers of Texas and Southwestern Cattle Raisers Association. Where the law is miles of fence and open pasture, justice rides with a smaller badge. 1. Who they are. This article creates Special Rangers for the Texas and Southwestern Cattle Raisers Association. The Director of the Department of Public Safety of the state of Texas may appoint up to 50 Special Rangers employed by the association. 2. What are their powers and duties? Special Rangers aid law enforcement in investigating theft of livestock or related property. May arrest and use all powers given to peace officers under the Code of Criminal Procedure when necessary to prevent or stop an offense involving livestock or related property. Limits and conditions. They may not issue traffic citations for driver's license or general traffic offenses. Not entitled to state peace officer benefits. Must be approved and licensed like other peace officers. Application through the association, certificate of authority from the Department of Public Safety, license from the Texas Commission on Law Enforcement. The association is liable for their acts within the scope of employment. The state is not. The association pays all costs of appointments and revocations. Exam memory hook. Special Rangers equals livestock theft specialists. Full peace officer authority only when dealing with livestock-related offenses. No traffic tickets. No state benefits. Association pays and carries the liability. Adjunct police officers. Some posts are too small for a full garrison, so the law lets the town borrow its guards. 1. Who they are. Adjunct police officers are college or university police officers from a private institution of higher education in a smaller county, temporarily appointed to also serve as municipal or county police in a defined area around the campus. Key points. The school must be private, located in a county with under 200,000 population. With the consent of the school's governing board, the municipal chief of police or county sheriff may appoint up to 50 of that school's commissioned officers under Education Code as adjunct police officers for the city or county. 2. What are their powers and duties? Adjunct police officers shall aid law enforcement in protecting the municipality or county within a designated area, may make arrests and exercise all peace officer authority, but only inside the agreed geographical area. The designated geographical area must include the campus, may include only an area adjacent to the campus, no more than 1 mile from the campus perimeter, primarily inhabited by the school's students or employees. Benefits and liability. They have the rights, privileges, and immunities of peace officers, but no state pay or state retirement benefits. The private institution is liable for their acts outside the campus in the same way the city or county is liable for its regular officers. Appointment and removal. The school submits the officer's application. The chief or sheriff issues a certificate of authority. The officer must complete any extra training needed to meet local standards. The chief or sheriff may revoke the certificate for good cause. To summarize, adjunct police equals private college cops temporarily borrowed by city or county, with peace officer powers only on campus and in a 1-mile student-heavy zone, and the school pays and holds liability outside campus. School marshals. When the innocent gather in classrooms, the law hides its sword among them. 1. Who they are. School marshals are specially trained, licensed individuals appointed to provide armed security and emergency response for public school districts, open enrollment charter schools, private schools, as defined in the article, public junior colleges. They are not regular patrol officers. Their mission is school safety against serious violent threats. 2. What are their powers and duties? A school marshal must be licensed under Occupations Code Section 1701.260, School Marshal License. Be appointed by the appropriate school or college governing body under the Education Code. Once appointed, and subject to written regulations adopted by the school or college, a school marshal may make arrests and exercise all authority given peace officers under the Code of Criminal Procedure, but only as allowed by the school's written policies, and only as necessary to prevent or stop an offense that threatens serious bodily injury or death to a student, staff member, or visitor on school premises. Limits and conditions. No traffic citations. They cannot issue tickets for driver's license or general traffic offenses under the Transportation Code. They are not entitled to state benefits normally provided to peace officers, pay, retirement, etc. To summarize, school marshals equals embedded school defenders. Peace officer type powers only on school property, only to stop deadly or serious violence, no traffic tickets, no state benefits. A summarization of the different types of peace officers. Peace officers generally. These are the ones the state fully trusts. Sheriffs, police officers, constables, rangers. They carry the full weight of the badge. Their duty: to preserve the peace, prevent crime, execute the law, and arrest when authorized, with all powers granted to peace officers and the general duties imposed by Article 2.051. Special investigators. They serve another authority, and the state allows them to borrow its hand. Federal agents walking Texas ground. They are not Texas peace officers. Their duty:
to arrest, search, and seize under Texas law only in specific felony or mission-based circumstances, and only within the limits the law allows.
Their power is granted, not owned.
Tribal Council Peace Officers. A nation within a nation still keeps the peace. Commissioned by tribal authority. Their duty, to enforce the law with full peace officer power on tribal land, and to act only in assistance when beyond it. Their badge speaks strongest on their own ground. Peace officers from adjoining states. The border does not end the chase, but it does restrain it. Officers from neighboring states who cross into Texas. Their duty, to maintain or regain custody of prisoners during border transports, and to act with limited authority in certain border cities when the law allows. Their reach is narrow and carefully watched. Railroad Peace Officers. Steel and freight move fast. The law stations guardians along the rail. Commissioned by the railroad. Their duty, to protect railroad property, passengers, and employees, and nothing more. No traffic enforcement, no state protection. The railroad pays their cost and bears their burden. Special Rangers of the Texas and Southwestern Cattle Raisers Association. Out where the land is wide, theft still leaves a mark. Livestock theft specialists. Their duty, to investigate and stop crimes involving livestock and related property, and only those crimes. No traffic authority, no state benefits. The association pays, and the association answers. Adjunct Police Officers. When a town is small, the law borrows its watchmen. Private college officers temporarily sworn to serve city or county. Their duty, to protect the campus and the surrounding ground, no farther than 1 mile beyond it. Their power ends where their ground ends. Their school pays the cost. School marshals. Where children gather, the law hides its blade. Armed protectors placed inside schools. Their duty, to act only to stop threats of serious bodily injury or death on school grounds. No traffic authority, no general patrol, no state benefits. They exist for one moment, the worst one. The law does not ask who you are. It asks where you stand, and how far your authority reaches. Duties of peace officers. Power is never given without expectation. The badge is not permission. It is obligation. General powers and duties of peace officers. This is the oath made into law. What the law requires, every peace officer shall. Preserve the peace within the officer's jurisdiction by all lawful means. Prevent and suppress crime, not merely respond after the fact. Execute all lawful process issued by courts and magistrates. Give notice to a magistrate of offenses committed within the officer's knowledge. Arrest offenders without unnecessary delay when authorized by law. Bring arrested persons before a magistrate according to law. Perform all duties imposed by law, not just the ones that are convenient. You are not allowed to ignore crime. You are not allowed to pick favorites. You are not allowed to delay justice out of comfort or fear. The law does not ask if you feel ready. It asks if you are sworn. Intervention required for excessive force. Report required. Silence is not neutrality. It is consent. What the law requires. If a peace officer observes another peace officer using excessive force and is in a position to safely intervene, then that officer shall intervene to stop or prevent the excessive force. Report the incident to a supervisor according to agency policy. You are accountable not only for what you do, but for what you allow. Failure to intervene or report is itself a violation of law. The badge does not shield cowards. Duties of law enforcement agency filing case. Justice begins with records, not rumors. What the law requires. When a law enforcement agency files a case, the agency must ensure required reports, information, and documentation are properly prepared and submitted. This includes ensuring accuracy and completeness so prosecutors and courts can lawfully proceed. A sloppy case file is not a mistake. It is a failure of duty. If the record fails, the case fails. Fine for failure to execute process. Ignoring the court is not discretion, it is defiance. What the law requires: a peace officer who willfully fails or refuses to execute lawful process, such as warrants or court orders, may be fined. Court orders are not suggestions. If the court issues lawful process and you are responsible for executing it, you must act. Sheriff as conservator of the peace. Where order weakens, the sheriff stands. What the law requires: the sheriff is the primary conservator of the peace in the county, has a duty to prevent crime, suppress disturbances, execute lawful process, maintain public order. The sheriff is the final authority for peacekeeping at the county level. Sheriff's duties related to custody of defendants. Those held by the law must not be forgotten by it. What the law requires: the sheriff is responsible for safekeeping persons lawfully committed to the county jail, ensuring defendants are properly housed, properly presented to court, lawfully detained. Custody is not punishment, it is responsibility. Neglect of detainees is neglect of duty. Deputy or other officer to discharge sheriff's duties. Authority does not vanish when shared. What the law requires: a deputy sheriff or other authorized officer may lawfully perform the duties of the sheriff. Acts performed by deputies carry the same legal authority as if performed by the sheriff. When acting as a deputy, you are not almost the sheriff. You are the sheriff's authority, acting in their name. Investigation of certain reports alleging abuse, neglect, or exploitation. The vulnerable are not optional. The law commands their defense. What the law requires: peace officers shall investigate reports of abuse, neglect, or exploitation involving elderly persons, disabled persons, vulnerable individuals. Coordinate with appropriate agencies as required by law. These cases are not optional. They are mandatory. Delay places lives at risk. Misused identity notifications. When a name is stolen, justice must answer. What the law requires: when identity misuse or identity theft is reported, peace officers must provide the victim with information about the report, required notifications, documentation necessary to correct records. Identity crimes do not end with arrest. They leave damage behind, and the law requires you to help address it. Some crimes do not break bones. They break names. Peace officers report in connection with certain offenses involving sensitive information. When identity is stolen, the damage is quiet. No blood, no noise, just a life made harder piece by piece. The law does not allow this harm to pass undocumented. What the law commands: when a report is made alleging identity theft or misuse of identifying information, the peace officer must write. Not eventually, not if convenient. Must. The record must name who was harmed, who is suspected, if that name is known, what was taken, not vaguely, but precisely, and what the investigation has uncovered so far. The law does not tolerate careless memory. It demands a written account. This is not optional diligence. It is duty. Why the law is exact: identity crimes do not end when the offender walks away. They continue through banks, employers, courts, and records. If the report is vague, the damage spreads. If the report is careless, the victim is harmed again. So the law requires precision. Not more words, the right ones. Accuracy is protection. The victim's place in the record. If the victim asks for the report, the law says it must be given. Not as a favor, not as a courtesy, as a right. But the law is careful. What must be shared is shared. What must be protected is guarded. Names, methods, and information that do not belong in public hands are removed. Truth is owed to the victim. Exposure is not. Peace officers report concerning certain assaultive or terroristic offenses. Violence does not fade when the moment ends. If it is not written down, it will return unseen. What the law applies to. This duty is not general. It is precise. It applies only when a peace officer investigates the alleged commission of assault, aggravated assault, Sexual assault, aggravated sexual assault, terroristic threat, what the law commands. When you investigate one of these offenses, you shall prepare a written report. Not if the case seems small, not if the suspect is known, not if the victim hesitates. Shall. The report must include all information required by law for family violence and assault of offense reporting, as incorporated by statute. This means the report must be complete, structured, and detailed, not minimal. Memory is not evidence. Record is. Why the law is strict. These offenses are not isolated acts. They are patterns. The law requires documentation so that escalation can be seen, repetition can be stopped. Victims are not forced to prove danger from the beginning every time. What is written once can protect many later. The victim's right. If the victim requests information from the report, the law enforcement agency must provide it, at no cost, as long as the information is not legally exempt from disclosure. This is not discretion. It is obligation. The victim is not a bystander to their own case. Use of neck restraints during search or arrest prohibited. What the law requires, peace officers may not use neck restraints during searches, arrests, except in very narrowly defined lawful circumstances if allowed elsewhere. Certain force techniques are forbidden, not discouraged, forbidden. Violating this article is not poor judgment. It is unlawful force. Duty to request and render aid. The badge does not excuse indifference. What the law requires, peace officers shall request emergency medical assistance when a person is injured or appears to need care. Provide reasonable aid consistent with training until medical help arrives. Once a person is in your custody, their survival becomes your responsibility. You may restrain them, but you may not abandon them. One truth to remember. The Code of Criminal Procedure does not describe heroes. It describes duties. Every article above exists to answer one question. What must a peace officer do, even when it is hard, inconvenient, or unpopular? Family violence. Duties under the Code of Criminal Procedure. What happens behind closed doors still answers to the law. This is not a private matter. It never was. What the law declares. The legislature formally states that family violence is a serious criminal justice issue. Law enforcement has a primary responsibility to protect victims, prevent further violence, enforce the law without hesitation. Family violence is not treated as a civil dispute. It is not dismissed as a domestic issue. Peace officers are commanded to intervene. The law does not wait for permission when lives are at risk. Definitions. Before justice acts, it defines. What the law does. This article defines key terms used throughout family violence enforcement, including family, household, member of a household, family violence, dating relationship. These definitions control. When family violence duties apply, when mandatory arrest provisions may apply, when protective orders and special victim rights attach. If you misunderstand these definitions, you misunderstand the law. Words decide whether protection begins. Family or household relationship does not create an exception to official duties. Blood does not excuse bruises. What the law commands, a peace officer's duties do not change simply because the offender and victim are married, related, living together in a dating relationship. Family or household status never excuses criminal conduct. You may not decline to act because they are spouses. Tell parties to work it out. Ignore probable cause because of family ties. The badge answers to law, not kinship. Duties of peace officers. This is where obligation becomes action. What the law requires when responding to family violence. A peace officer shall protect any potential victim of family violence, enforce the law, including protective orders and bond conditions, make lawful arrests when probable cause exists, provide written notice to adult victims that includes their legal rights, available protective orders, information about shelters and support services. Your role is not mediator. Your role is protector and enforcer. Failure to act is not neutrality. It is abandonment. Standby assistance. Liability. What the law allows. At a victim's request, peace officers may stand by while a victim retrieves personal belongings, leaves the residence safely. Legal protection officers and agencies are granted limited civil liability protection when acting, in good faith, within the scope of their duties. The law allows you to help victims escape danger without fear of punishment, as long as you act lawfully. The law shields those who shield others. Reports and records. If it is not written, it did not happen. What the law requires, peace officers must create a detailed written report for family violence incidents, including names of involved parties, relationship of parties, injuries observed or reported, statements made, presence of children, weapons involved, determination of the primary aggressor. These reports become part of court records of protective order proceedings, future risk assessments. A weak report endangers future victims. Documentation is protection delayed, but protection still. Venue for protective order offenses. What the law provides. An offense involving the violation of a protective order may be prosecuted in the county where the violation occurred, the county where the protective order was issued, other counties as allowed by law. Offenders cannot escape accountability by crossing county lines. Distance does not dissolve responsibility. Additional rights of victims of certain family violence offenses, stalking, and violation of protective order or condition of bond. Survival grants more than sympathy. It grants rights. What the law guarantees victims. Victims of these offenses have additional rights, including being informed about protective orders, bond conditions, release or escape of the accused, having their safety considered in bail and release decisions, receiving clear communication from law enforcement about available protections. Victims are not bystanders in their own cases. The law listens to those it protects. Duties of officers relating to threats of injury or death to persons or damage to property. The law does not wait for blood to be spilled. A spoken threat is already a crack in the wall. What the law requires. When a peace officer receives credible information that a person is threatening to injure or kill another, or is threatening to damage or destroy property, the officer shall take lawful measures to prevent the threatened harm and preserve the peace. This duty exists before an offense occurs, meaning you do not need to wait for the attack. You are authorized and required to act when the danger is foreseeable. The law allows intervention before regret becomes evidence. Peace officer to prevent injury. When danger is known, restraint becomes duty. What the law requires. The peace officer must use the amount of force necessary to prevent the commission of the offense, and no greater. Prevent an individual from injuring themselves, injuring another person, committing violence against property. This includes de-escalation, separation of parties, detention or arrest if authorized, requesting emergency mental health intervention when appropriate, meaning this article imposes an affirmative duty to intervene. Standing by while foreseeable harm occurs is not allowed. Conduct of peace officer. What the law requires. When acting under Articles 6.05 or 6.06, a peace officer must use the amount of force necessary to prevent the commission of the offense, and no greater. Act with reasonable judgment. Use only the amount of force necessary. Remain within lawful authority. The goal is prevention, not punishment, meaning you are judged not only on whether you acted, but how you acted. The law measures restraint as closely as power. Request for protective order. Some warnings must be written into law. A protective order may be requested in court when the defendant appears before a court. The case involves a crime against a person or certain property offenses, and it is alleged the offense was committed because of bias or prejudice. Any person may request the order. Only the court may issue it. To summarize, court proceeding plus bias-motivated offense equals protective order may be requested.
v. Article 7, B.051, Request for Protective Order.
What the law requires or allows. When a defendant appears in court for a stalking offense, a person may request a protective order. Duties of officers relating to suppression of riots and other disturbances. When many lose restraint, the law must regain it. Officer may require aid. Order does not always stand alone. What the law authorizes. A peace officer may command the assistance of bystanders to suppress a riot, overcome resistance, preserve the peace. A person who refuses without lawful excuse may be subject to penalty, meaning, in extreme disorder, the law allows officers to draw on the strength of the community. Dispersing riot. Crowds are not innocent when they become weapons. What the law requires. When a riot occurs, peace officers shall command the rioters to disperse and use lawful means to restore order if the command is ignored. This includes arresting those who refuse to comply, meaning you must give the chance to comply. But once defiance is clear, the law permits decisive action. Officer may call aid. Some storms require more hands. What the law allows. A peace officer may call upon the additional peace officers, organized groups, or other lawful aid to assist in suppressing riots or violent disturbances, meaning you are not required to face chaos alone. Means adopted to suppress. Force is measured by necessity, not anger. What the law permits, peace officers may use whatever lawful means are reasonably necessary to suppress riots, prevent injury, restore order. The standard is necessity, not excess, meaning escalation must be justified by conditions, not emotion. Article 8.07, Unlawful Assembly. When gathering becomes danger, the law intervenes. What the law defines and authorizes. An unlawful assembly occurs when people gather with intent to commit an unlawful act or commit a lawful act in a violent or dangerous manner. Peace officers may order dispersal, arrest those who refuse, meaning the law intervenes before violence fully ignites. Article 8.09, Power of Special Constable. In rare moments, the law appoints more hands. What the law provides. A special constable may be appointed to assist peace officers during riots or disturbances. While appointed, the special constable holds authority necessary to help restore peace, under direction of lawful command, meaning, when order is strained, the law temporarily expands its reach, but always under control. Final truth to remember. The Code of Criminal Procedure does not wait for chaos to finish its work. It commands peace officers to act while peace is still possible. 9.7. Duties of officers relating to protective orders for victims of sexual assault. Code of Criminal Procedure, Chapter 7. Some crimes do not end when the attacker leaves. The law exists to keep them from returning. A protective order duties. Application for protective order. Protection begins when the law is asked to stand watch. A protective order may be sought without regard to relationship when a person is the victim of specific serious offenses, including sexual violence, trafficking, stalking, exploitation, and certain burglary offenses listed by law. Who may file? An application for a protective order may be filed by the victim of a listed offense, any adult, including a parent or guardian, acting for a child victim, or an adult ward, a prosecuting attorney acting on behalf of the victim. In limited cases, a state sexual offense response coordinator with the victim's consent. When the victim cannot stand alone, the law allows another to stand for them. Mandatory duty of the prosecuting attorney. If no application has already been filed, the attorney representing the state shall file an application for a protective order after conviction or deferred adjudication for certain listed offenses. An adult victim may refuse this filing. A child victim or adult ward may not be opted out. Where the law sees continued danger, it does not wait for silence. Where the application may be filed. The application may be filed in a district, statutory county,
constitutional county, or juvenile court with district court jurisdiction in the county where the victim resides, the county where the offender resides, or any county where an element of the offense occurred, or any court already exercising protective order jurisdiction over the same parties. Form requirement. The application must be filed using the official protective order form created by the Office of Court Administration. Temporary ex parte order. When danger is immediate, the law does not wait for debate. A court may issue a temporary ex parte protective order without notice and without a hearing when the application shows a clear and present danger that the applicant may suffer. 1. Serious criminal conduct listed by law, including sexual assault, aggravated sexual assault, indecency or sexual abuse involving a child, trafficking or exploitation offenses, stalking or other serious offenses specifically listed in Article 7B.001. These are harms the law has already judged severe. 2. Other harm to the applicant, meaning a real and immediate risk of physical injury, sexual harm and continued abuse, coercion or exploitation, or conduct showing the danger has not ended. This does not require the harm to have already occurred, only that the danger is present and credible. How the court decides. The decision is made from the application alone. The accused is not present. No hearing is required at this stage. Special statutory rule. If the applicant has been issued a military protective order because they were a reported victim of sexual assault, that order by itself is enough for the court to find a clear and present danger. No additional showing is required. This order is temporary. It exists to hold the line until the court can hear the case fully. It does not decide guilt. It decides safety. This is not judgment. It is restraint. Required findings. Issuance of protective order. The law does not act on fear alone. It requires proof, then commands restraint. What the court must find. A qualifying offense occurred, including cases proven by conviction or deferred adjudication. Once these findings are made, the court shall issue the protective order. Officers' duty. Peace officers must respect the court's findings, enforce the order strictly. Understand that violation is a separate criminal offense, regardless of whether new violence occurs. Meaning, likelihood is enough. The law does not require a second wound. Hearsay statement of child victim. In a hearing on an application for a protective order, a statement made by a child under 14 years of age, who is the victim of a listed sexual offense, may be received as evidence even if it is hearsay. The statement must describe the offense committed against the child, and is admitted under the same reliability rules used in child abuse cases. This allows the court to act without forcing the child to testify. The law weighs truth without demanding another wound. Conditions specified by protective order. Protection is not abstract. It is written in commands. A protective order may require action or impose restraint, as the court finds necessary to prevent further harm. The court may order the alleged offender to take specific actions the court determines are necessary to reduce the likelihood of future harm. The court may also prohibit the alleged offender from communicating with the applicant or family or household members directly or indirectly in a threatening or harassing manner, or in any manner at all, except through attorneys or court-appointed persons, when good cause exists. Going to or near specified locations, including a residence, workplace, school, or child care facility. Engaging in harassing, following, stalking, or tormenting conduct directed at the applicant or family or household members. Possessing a firearm, except when the alleged offender is a peace officer actively engaged in sworn full-time employment. Tracking or monitoring the applicant or their property, electronically or physically, without effective consent. When location restrictions are imposed, the court must specifically name each prohibited location and set the minimum distance to be maintained, unless confidentiality is required. The court may also suspend a license to carry a handgun held by the alleged offender. The law does not warn vaguely. It draws lines. Peace officers must know that every condition is enforceable. Enforce the order exactly as written. Act when probable cause exists for any violation, direct or indirect. Meaning, the order is the boundary, cross it, and the law responds. Warning on protective order. The law does not whisper its commands. It writes them where no one can claim ignorance. What the law requires, every protective order issued under this subchapter, including a temporary ex parte order, must plainly warn that violation of the order is punishable as contempt of court, with penalties of a fine up to $500, confinement in jail for up to 6 months, or both. No one may give permission to violate the order, including the person protected by it. Every provision remains in force unless changed by a court. A person subject to the order may not possess a firearm or ammunition, unless the person is a peace officer actively engaged in sworn, full-time employment. Every protective order other than a temporary ex parte order must also warn that a violation may be punished by a fine up to $4,000, confinement in jail for up to 1 year, or both. An act that violates the order may also be prosecuted as a separate criminal offense if the conduct itself constitutes a crime. Peace officers must treat the warning as proof of notice, enforce the order as written, reject claims of ignorance once the order has been served. Once warned, defiance is intentional. Duration of protective order, rescission. Protection lasts as long as danger remains. What the law provides, a protective order may last up to 2 years, or longer if the court finds serious danger or repeated violations. A court may rescind or modify the order only under lawful conditions. Officer's duty. Peace officers must enforce the order for its full duration. Treat expired orders differently from active ones. Never assume an order is invalid without confirmation. Meaning, time does not weaken danger. Only law can. 8. Article 7, B.008. Application of other law. This article does one thing. Protective orders issued under this subchapter are governed by Title 4 of the Family Code, unless this subchapter clearly says otherwise. Final truth to remember. A protective order is not paperwork. It is the law standing between a victim and their attacker. Your duty is not only to arrest after harm, but to enforce the boundaries that prevent it. Duties of officers relating to the investigation of sexual assault. Some crimes leave no visible wound. The law still demands that they be taken seriously. Polygraph examination of complainant prohibited. Truth is not measured by wires and needles. What the law forbids, a peace officer may not require a complainant of sexual assault to submit to a polygraph examination as a condition of continuing the investigation or filing or pursuing criminal charges. This prohibition applies regardless of the officer's doubts, the complexity of the case, the absence of physical evidence, meaning you may investigate, you may question, but you may not place the burden of proof on the victim. The law does not test survivors to earn belief. Article 56, .052. Additional rights of victims of sexual assault, indecent assault, stalking, or trafficking. This article grants specific additional rights, available on request, to victims of certain sexual offenses, trafficking offenses, stalking, and related crimes. These rights govern information, evidence, medical care, prosecutorial decisions, and access to protective orders. Victims, guardians, or close relatives of deceased victims are entitled to be informed about what evidence was collected during the investigation, the status of forensic and laboratory testing, requests to compare biological evidence with state or federal DNA databases, the results of those comparisons, when disclosure will not interfere with the investigation or prosecution, or, if disclosure is delayed, the estimated date the information will be released. Medical and health-related rights, on request. Victims are entitled to HIV and AIDS counseling, medical testing related to exposure, a forensic medical examination, and medically necessary follow-up care for 30 days after the examination. The harm is not only legal, The law answers the body as well. Rights involving the attorney representing the state, on request. Victims may be informed about and confer with the attorney representing the state regarding a decision not to file charges, dismissal of charges, use of a pretrial intervention program, or a plea bargain agreement. Justice is not decided without hearing the injured. Protective order rights for offenses specifically listed in Article 7B.001. For victims of the following offenses, the law grants additional protective order rights. Sexual and child victim offenses. Continuous sexual abuse of a young child or disabled individual. Indecency with a child. Sexual assault, indecent assault, aggravated sexual assault. Trafficking offenses. Trafficking of persons. Continuous trafficking of persons. Stalking. Certain burglary offenses. Burglary, but only when charged under the most serious provisions involving intent to commit serious crimes. For victims of these offenses, the law guarantees the right to be informed that a protective order may be filed, the right to know which court has jurisdiction to issue the order, the right to request the prosecutor file the application on the victim's behalf, the right to be notified when the application is filed, and the right to immediate filing of a protective order following conviction or deferred adjudication when the court has jurisdiction. Victims requesting notice must provide current contact information, update changes as needed, or designate another person or service entity to receive notice, excluding the accused. Certain victims of trafficking offenses must be informed of their right to seek non-disclosure of criminal history record information when their own offense resulted solely from being trafficked. The law does not punish the chained for the crime of captivity. To summarize, evidence transparency, forensic notice, medical care, prosecutor consultation, Chapter 7. B. Protective order access for specifically listed offenses and non-disclosure for trafficking victims. Article 56. Point 403. Duties of peace officers regarding victims of sexual assault. This is where authority is tested, not by force, but by care. When a peace officer investigates a sexual assault or responds to a call that may involve sexual assault, the law imposes mandatory duties. These are not optional. They must be performed at initial contact or as soon as possible thereafter. The peace officer shall provide the victim with written notice containing information about the victim's rights under Article 56.052 and information about rights and procedures under Chapter 58, including use of a pseudonym. Rights not delivered are rights denied. Mandatory actions at initial contact. At the first contact or as soon as possible afterward, the peace officer shall provide a written referral to the nearest sexual assault program, provide information about the statewide electronic sexual assault evidence tracking system, offer to request a forensic medical examination on the victim's behalf, coordinate with the local sexual assault response team to ensure continuing care or further investigation, provide all required written notices specified by law. The written notice must be provided in English and Spanish, include current contact information for a crime victim liaison and a victim assistance coordinator. Inform the victim that causing physical injury or harm is a crime. The victim should report injury or fear of danger. A forensic medical examination may be obtained within 120 hours, even without making a police report. Evidence may be tracked anonymously. A sexual assault advocate may be present during the forensic examination and any law enforcement interview. The victim may request the prosecutor file charges. If the suspect is arrested, the victim may request an order for emergency protection, request a pseudonym under Chapter 58, apply for a permanent protective order. No fee may be charged for filing, serving, or entering a protective order. The notice must also include contact information for local sexual assault programs, locations where forensic medical examinations may be obtained, information for the National Human Trafficking Hotline. The law does not assume knowledge. It places it in the victim's hands. Each law enforcement agency must consult with local sexual assault programs or response teams to develop the written notice.
Update the notice at least once every biennium. Ensure the notice remains accurate and complete, meaning, this investigation is not an interrogation. It is a duty to protect without causing new harm. Evidence matters. So does how the law reaches the wounded. To summarize, mandatory written notice, immediate referrals, exam offers, evidence tracking info, response team coordination, and specific victim rights delivered at first contact. Presence of sexual assault program advocate or other victim's representative during law enforcement interview. No one should face justice alone after violence. This article governs who may be present during a law enforcement interview of a sexual assault victim, under what conditions, and with what limits. Who this applies to. Applies to victims reporting sexual assault. Applies before an investigative interview begins. Does not apply to minors. Minors are handled under separate law. Primary mandatory duty. First offer. Before conducting the interview, the peace officer shall offer the victim the opportunity to have a sexual assault program advocate from a qualifying sexual assault program who has completed required sexual assault training, if the advocate is available at the time of the interview. Secondary mandatory duty, if no advocate is available. If a sexual assault program advocate is not available, the officer shall offer the victim the opportunity to have one of the following present: a crime victim liaison from the law enforcement agency, or a peace officer who has completed the required sexual assault training, or a victim assistance counselor from a state or local agency or other qualifying entity. Good faith requirement, with limits. The officer must make a good faith effort to comply with these requirements. However, compliance may not unreasonably delay or impede the interview. Attorney presence, separate and explicit right. The victim has the right to have an attorney present during the interview. The attorney may not unreasonably delay or impede the interview. Any advocate, liaison, officer, or counselor present may only provide counseling and emotional support, and provide information about crime victim rights. They may not answer questions for the victim, influence testimony, direct the interview, control the investigation. No unreasonable delay rule applies to everyone. The advocate, liaison, officer, counselor, and their providing entity may not unreasonably delay or impede the interview process. Costs and liability. The sexual assault program pays all costs for providing an advocate. Any entity providing a liaison, officer, or counselor pays its own costs. Any person or entity providing access is not civilly or criminally liable for doing so. Via Article 58.102. Designation of pseudonym, pseudonym form. A name should not become another weapon. What the law allows victims to do. A victim of sexual assault may choose to use a pseudonym instead of their real name in public records reports, certain court documents. This requires completion of a pseudonym form. Officer's duty. Peace officers must inform the victim of this right. Use the pseudonym where required. Protect the victim's true identity from unauthorized disclosure, meaning privacy is protection. Offense, pseudonym, disclosure. Some names are buried so the living may endure. To unearth them without cause is a crime. This article creates a specific criminal offense for wrongful disclosure of a victim's identity when a pseudonym has been chosen under law. Who can commit the offense? Victim 17 years of age or older. Only a public servant commits the offense. If the public servant has access to the victim's protected information and knowingly discloses it unlawfully. Victim younger than 17 years of age. Any person may commit the offense, unless disclosure is required or permitted by law. With age comes restraint by office. With youth, restraint binds everyone. Only the following information is protected under this article: name, address, telephone number. No other information is covered by this statute. Disclosure is unlawful if made to a person not assisting in the investigation or prosecution, or any person other than the defendant, the defendant's attorney, a person specifically authorized by court order. Need to know is the boundary. Beyond it lies offense. Affirmative defense, minors only. For victims under 17 years of age, it is an affirmative defense if the person who disclosed the information is the victim or the victim's parent, conservator, or guardian, unless that person is the alleged offender. A guardian may speak, unless they are the hand accused. Penalty. An offense under this article is a Class C misdemeanor. The punishment is small. The breach of trust is not.